month, once every 2 months. So the terms exactly weren't clear, and because they weren't clear, then an offer was not deemed to have been made. So the terms in a contract, in the offer, must be absolutely clear, otherwise an offer won't exist, and if you don't have an offer, then you don't have one of the elements that is required for the formation of a valid contract. So when we're looking at offer, so we are looking at offers that can be made verbally, or in writing, by email, by fax, by telegram, by newspaper. And again, just to remember that you need to look at the objective test, unilateral test, invitation to treat, and revocation of an offer, and postal rule, which we will come on to later. Now, the second element in a contract, or what is required for a valid contract, is acceptance. So one person makes the offer, and then the other person needs to accept the offer. So when we look at acceptance, we first have to define what we mean by acceptance. So acceptance can be seen as a unqualified acceptance of all the terms and conditions which are not modified in any way, shape or form. And there are various things about acceptance that we need to get clear. Firstly, silence is not a form of acceptance. We've seen this in Fenthouse versus Bingley, 1863, where an uncle was going to buy a horse from his nephew, and the horse was going into auction, and the uncle said, well, I'll buy this horse for X amount of pounds for this price, but if I don't hear from you, I will assume that the contract has been made and you've accepted. In fact, unfortunately, the nephew didn't really get the offer from the uncle, so he subsequently sold the horse in the auction. The uncle then took the nephew to court, and it was held that, in fact, there was no acceptance. There was no acceptance because silence is not a form of acceptance. Okay, and then the only other thing that we need to look at when we're viewing the acceptance is the Postal Rule. The Postal Rule says that when a letter has been posted, then acceptance has been deemed to have been made. Now, there's a bit of ambiguity here, because let's take the instance in the case of Adams versus Lindsell, 1818, where it was for some sale of some wool, and the letter left making the offer for the sale on the 2nd of September, and then the letter from being delayed wasn't received until the 5th. But when it was received on the 7th, it was accepted and then posted. Unfortunately, the letter didn't actually get to the party until the 9th, but on the 8th, the party had sold it, thinking that they hadn't heard anything from that person. So here we can see that even though they hadn't received a letter of acceptance. Yes.
Is that yours?
It is, yes.
Is there any chance you could put it in the main car park?
Yes. Could I do it in about 15 minutes?
Oh, you just do it?
Yes.
Yeah.
Yes. Thank you. Thank you.
Hello, you alright?
Yeah. I've just been asked to move my van. I'll move to my van in a second. So, again, we can see that for a letter to be properly posted, it must be stamped, it must be addressed properly, and it must have been posted correctly. But once the point here is that once the letter has been posted properly and correctly, then acceptance has been made. Even if the letter gets lost and doesn't actually get to the person, it doesn't matter. Acceptance has been made, so there's been as long as all the other elements exist: offer, acceptance, consideration, capacity, legality, intent to create legal relations. If they all exist, then there is a legally binding contract. So if that person sells those goods and there's a legally binding contract, then that person is in breach of contract. Okay, so with acceptance, you just need to take into consideration the Postal Rule, and also you can't put in a contract that if someone makes an offer and they say, well, if I don't hear from you, then I deem acceptance to be made. That's not the case. Silence is not a form of acceptance. So we've covered offer and acceptance. The next part to look at is consideration. Consideration is defined as some right, interest, profit, or benefit to one party, or some forbearance, determinant, loss, or responsibility given, suffered, or undertaken by another. So I'll say that again. So that's some right, interest, profit, or benefit to one party, or some forbearance, determinant, loss, or responsibility given, suffered, or undertaken by another. In today's age, we see consideration as being money. In the majority of cases today, consideration is in the form of money. So if we go into a shop, we buy something, there's an offer acceptance. Consideration is when we give something of value, and that's going to be that monetary value of money. So in the majority of cases today, in the UK, for example, we do use money as the main source of consideration. Now, with consideration, you do need to look at executory consideration. Executory consideration is consideration which is being paid at a later date. And then you've got executed. Executed consideration is where the act has been performed all in the same instance. Offer, acceptance, consideration, where it's paid at the same time. It's actually been executed. And some other points about consideration. We can see that consideration need not be adequate, as in the case of Thompson versus Thompson 1842. In fact, consideration, if you were to buy something, only needs to be of £1 value. It doesn't need to be greater than £1. When we look at past consideration is insufficient. So you can't have past consideration as being sufficient for that service. And that's seen in MacArthur 1951. Other points about consideration. So performance of an existing duty is not considered to be consideration. So if you're performing an existing duty, that itself will not be deemed to be part of consideration for another contract. Okay, and that's seen in the case of Collins versus Godfrey, 1831. But there is an exception to the rule, and the exception to the rule is whereby performance of an existing of an existing duty is exceeded. And performance of an existing duty which is exceeded can then be considered to be consideration for another contract. Again, this is seen as Glamorgan County Council versus Glassbrook Bros Limited, 1925. So again, we can see, consideration will either be sometime in the future, or consideration will be at that same point. And in the majority of cases for us, when we're buying things and entering into contracts on a daily basis, we are entering and completing the contract straight away, giving the consideration, giving the money, or putting our credit cards in straight away. And then the next thing that we need to look at really is the intention to create legal relations. Capacity first. Let's take capacity. So capacity really, is the person of legal age to enter into that contract in the first place, and not only are they of legal age to enter into a contract, like a minor will not have the capacity to enter into a contract to buy alcohol in the UK of up to 18 years old. So he will not be legally enabled to do that. He won't be in his capacity to do that legally. But also, someone might not have the mental capacity to enter into a contract, and in the same way, that person, it may be deemed, depending upon the circumstances of the case, that they may not be have the right capacity, and therefore not a legally binding contract. But there are some exceptions to this rule as regards to capacity. In instance where children have to make a living or have a home, then under certain circumstances they are able to enter into contracts. Now, the last one we need to look at, which combining intention and legal relations, intention to create legal relations. This really means that both parties, firstly, it must be legal, because if it's not legal, then you can't enter into an illegal contract. And secondly, both parties must know exactly that they're actually entering into a contract. If one party only knows that they're entering into a contract, the other party doesn't know that they're entering into a legally binding contract, then again, all the elements won't exist and a legally binding contract will not be present. Various points to note about intentions. Firstly, domestic agreements are generally not binding, and we've seen this in Balfour versus Balfour 1919, when a husband promised to pay the wife X amount of money per month for living expenses, but then later on he couldn't or didn't want to pay it, and then we actually saw that it went to court, and the judge held no, this was a domestic agreement, and people in domestic agreements are not really